Let us understand the major and basic part of MCI regulated Regulation 2002 of Medical Ethics and Ethics, where Chapter 6 and Chapter 7 plays a vital role, and of course Chapter 8 also. So let us understand this chapter today and help your client whenever you are in call with them. As we have seen that all the 5 chapters are already been well defined to every aspect. It has defined that how the conduct of doctor must be, how the conduct of doctor with the patient must be, how the conduct of doctor with their colleagues must be, how the conduct of doctor with the paramedical professionals almost together, everything and how they need and approach the patient. Everything is well defined under the 5 chapters of earlier. Chapter 6 and Chapter 7 talks about misconduct and unethical acts. So what lawmaker had thought of as a misconduct for the doctors? So what they said, a physician shall not aid or abet or commit any of the following acts which shall be constituted as an unethical act. So what they have said, advertisement. As you all know, that advertisement was very strictly taken by the medical council, and doctors are not allowed to do their advertisement. In social era today, in social media today, we have found that huge number of advertisements are going for health sectors, and that is the only domain of during a patient. You go to cosmetic industry, IVF industry, you go to ART and other back industry, huge number of ads are there. Hospital industry, replacement, knee replacement, liver. So every industry is focusing on advertisement and huge investment is done on advertisement. Yes, earlier doctor was blocked. Now with the new law of Consumer Protection Act, even the institute has been blocked to give advertisement. In CP Act, penalty is of 10 lakh for first violation, 50 lakhs for second violation, jail punishment. Similarly, in Medical Council Act, doctors were suspended for doing wrong advertisement. And today in social era, the new NMC regulation 2023 came with the guidelines how you can use social media. But what was there and which is still be followed, that doctor cannot do advertisement. Very clearly they said, is soliciting patient directly or indirectly. Indirectly is a very wide word by physician. So indirectly also you can lure the patient by group of physician or by institution organized. So they have brought institution and organization also under purview of them. And the owner of the institute and organization being a doctor is punished. If non-medical, then hand of medical council is tied up. A physician shall not make use of him and her as subject of any form or manner of advertisement. So you cannot endorse, you cannot recommend to promote either by any methodology. What he can, they cannot endorse, they cannot do what was allowed. If you read the law, they have blocked everything except allowing that a medical practitioner who were permitted to make a formal announcement in a press, formal. What the limitation in a press means even on a website or even on any social media platform, how when you are starting a practice, change of type of practice, changing address, temporary representative duty, resumption of other practice, succeeding to other practice, public declaration. So these are the only things which are allowed by the medical practitioner through the regulation. Printing of self photograph. You find lots of visiting card coming with a doctor's photograph. So printing of self photograph on the way, any such material publicly in letterhead or signboard of the consulting room or any such clinical establishment shall be regarded as the act of self-advertisement and unethical conduct on the part of patient. However, printing of sketches, diagrams, pictures of human system shall not be taken. So you cannot print your photograph on any of the print material. So that was also very clearly have been blocked by the regulation 2000. Patent and copyrights. A physician may patent surgical instrument, appliances, so that is allowed. However, it shall be Unethical if the benefits of patents or copyright are not made available to institution where the interests of large population involved. So when you have done a patent, you need to help the large society with that patent. Running and shop, so dispensing of a drug and applying the patient. So they have very clearly said that medical store cannot be run by the physician. A physician should not run an open shop or sell of medicine. Now, new NMC Act, if you read NMC Regulation 2002, here they have little modified, and NMC Regulation 2023, if it comes with the same what was enacted, it says that doctor can sell a medicine to their patient. So little difference. Here you cannot sell, but there they said sell. But we are being bound by today by this regulation. So one shopper sell of medicine for dispensing prescription prescribed to doctors other than himself for sale of medicine or surgical plan. So doctor cannot sell. Even the Drugs and Cosmetic Act 1940 says that you can dispense, you can store, but you cannot sell if you don't have a medical store. It is not unethical for the patient to prescribe a supply drug, remedies, appliance as long as there is no exploitation. So they have given little margin to the doctors that they can do for their patient if you are not exploiting. Now, suppose you are selling a generic medicine to the patient on MRP. Definitely, if it is proven, it comes in exploitation. So exploitation should not be there. Drug prescribed by the patient or brought from the market for a patient should be explicit state the proprietary formula as well. So they have very clearly said what need to be. So you need to see that generic name and of the drug must be disclosed. They said rebate and commission is also banned. To solicit the patient, you cannot receive the gift, gratuity, commission, bonus, or other thing. Physician shall not directly or indirectly participate to the party or act of division, transfer, assignment. My friend, it was very clearly said. I still remember there was a case of Ratnagiri doctors who filed a complaint against the CT scan owner for giving a kickback to them for referring a CT scan patient. It was given to them in a check. Some patient got referred by him and they got the kickback and they filed a complaint in medical council saying that we are not interested in such a thing, but still we have been sent a check by the institution, which is absolutely bad in law. So action got initiated. So kickbacks, hurts, and other practices are blocked, but still people are following. I still remember a physician of mine who has appointed a PR for promoting his hospital and business. And naturally, like all, it's open secret, the cut practice was known. This personal relationship officer used to visit all general practitioners who used to refer a patient to the doctor or a hospital and used to give a packet to them, means their share of that. It is in cash and everything was maintained in their diary with the signature of a doctor, with signature of the physician. And one fine day, because of some conflict, this doctor has removed this PRO from the job and he blackmailed my doctor with that diary. And he said that I will approach Medical Council of India and I'll see that your registration in a state and exploited a doctor, extorted a doctor, and matter doctor was forced to settle that. So such a thing are really deadly combination. Referring, recommending, procuring physician. So everything is blocked under rebate and commission. Secret remedy. The prescribing or dispensing of patients secret remedy, the agent which we does not know the composition or manufacturing proportion or they are unethical. So this was also very seriously been taken. I still remember the case of one of my doctor was very famous in Mumbai for treating a paralytic patient. When I got this case, 17 years it was in the Medical Council of Maharashtra only for the purpose of unethical practice or using a secret remedies of giving some injection which composition was not known. Allegation that he used to remove the speaker from the ampule. The ampule is plain. No one knows what is that an ampule. And he used to treat the patient. There's a huge, always huge crowd on his clinic, a physician. So that was very seriously taken by the, now the doctors no more in this country, left abroad, but it was a very famous case. Human rights patients shall not aid, abet, torture, nor shall be the party to either infliction of mental, physical trauma or concealment of torture. So it is very much clearly blocked. Euthanasia, we have very clearly know that mercy killing or euthanasia is not a law in this country. We need to follow Organ Transplant Act. That's the reason when DNR status question comes to you, you need to be very careful before guiding him and advise them you can do but following the Transplant Organ Act 1994. The clause 6.8 as under included, which is annexure, this was included in 2009 on Code of Conduct of Professional Association, their relationship with health sector industry. So here they have very clearly blocked the pharma company in 2009 itself. They said gift, a medical practice shall not receive any gift from any pharmaceutical or allied health industry and their sales people or representative. So they have very clearly blocked doctor to get a gift, travel facility, hospitality like sponsorship and all, cash monetary grant. They have said medical research is allowed, but doctor should ensure that it has got due permission. These are the conditions clearance from national state, ensure that funding is publicly disclosed. So these are the riders put for allowing medical research. Other things has been blocked by maintaining a professionality and dealing with pharmaceutical and allied healthcare industry medical shall always ensure that there shall never be any compromise either with his or her own professional autonomy. And so naturally your autonomy should not go. Pharma should not buy you for their benefit. Affiliation, they said you can be affiliated with any pharma industry or with any of the institute. And they have again given the riders to that. Your professional integrity should be safeguarded. Patient interest is not compromised. So you can do a job. You're not being blocked to the job. Endorsement, they said you cannot endorse the product. So the riders are already put while allowing relation with the pharma industry. So be careful whenever the question comes. Now NMC are more clear. NMC has brought in single word directly, indirectly, and blocking the relation between pharma, which was very seriously taken, and NMC regulation 2023 was suspended for time being. We are waiting for amendments. Let amendment come, then we will talk on that.